afternoon. Thank you, everyone, for joining us today for the Wednesday webinar, which is Estate and Transition Planning. I'm Taylor Robinson, and I'll be helping to facilitate this session. We will be using the chat pod located at the bottom right-hand corner. Throughout this presentation, for questions, please use the arrow key to select everyone and type your question in. We will also be answering questions at the end of this presentation. So before we begin, I would like to say thank you to our sponsors and collaborators listed here on the slide. The blue link listed, which is extension umd.edu/women-in-ag, is where you can find the complete list of upcoming webinars as well as the archived webinars. I would now like to turn the presentation over.
So as we're thinking about this, the first question you have to ask yourself, is where are you in the process? If you ever get flustered or you forget, which PowerPoint presentation to open or something like that, you can always think of it in this case. That's where you're at right now in the universe. That at least gives you some perspective as you start thinking about this process, because this process is going to be really difficult in some cases for many of you to have to work through, because it requires you to think about your life at some point where you won't be here anymore and how your family will continue on. So the goal with most estate planning is to get you to where you want to go. If you come to one of the workshops, a lot of it is based around communication with your family members and other potential heirs. Why? Because we have to figure out what your goals are and what your family members' goals are in order to start facilitating this process, with the professionals that you're going to work with that we'll talk about here in a minute. The other thing you need to think about is, are we bringing other people into a family farm business, another family business? How exactly are we going to structure the business in a way so we can bring in multiple generations if it requires 2 generations to be, be able to be supported on the farm, and the farm only really supporting 1 generation to begin with? How do we do that at one time? And then we'll have to think about the estate plan. So developing the estate plan. 45% of those 55 or older do not have an estate plan. As we go up in age, typically past 45, and we start narrowing that down, that or older part down, more than likely you will have an estate plan. Why? You're contemplating your own death at that point. The problem is that when we look at it for the whole U.S. population, including people under 55, it goes up to 58% do not have any form of an estate plan. If you do this for ag and surveys I've seen from other states, it's pretty representative of the U.S. population. I've kind of already hit upon some of these. You'll have to designate powers of attorney, who's going to make your business decisions, who's going to make healthcare decisions for you. Hint, they may not be the same child or the same person in both cases. Some cases you'll have kids that will be able to make healthcare decisions better than business decisions. So we need to think about each one of these people's abilities, and I'll talk more in detail what a power of attorney is here in a minute. There may be advanced healthcare directives. These are also known as living wills. You have to consider this, and we'll talk about why here in a minute. There probably will be a will involved in all of this. There may be a trust. A lot of what the tools we use in this process depend on your goals. So a lot of estate planning, as I just said, is goal setting, and you need to think about those goals as we go along. Life insurance may be a part of this. If we're having to equalize things out between siblings, this may be one way we do it. There may be other ways we'll talk about here in a minute. I want everyone to look at these famous celebrities up. This is not can you name each one of these. As we contemplate this, the first thing we should think about is what happens when you die without an estate plan. Sonny Bono, Prince, Amy Winehouse, and Aretha Franklin all died without estate plans. I could broaden this to put in more celebrities. But we have to think about this. What happens if we don't have this estate plan? I often ask this question at estate planning workshops, who is this individual? If you know who this individual is, then you listen to rap music at one point in your life. This would be Snoop Dogg. Snoop Dogg is on the record as saying when he passes away, he does not want to have an estate plan. He wants to be reincarnated as a butterfly and watch his children fight over his estate. This is not a story from The Onion or another made-up comedy news site. This is a legitimate story that you can Google later after this webinar and see that he actually did see these things. Well, in Snoop's case, it doesn't matter if he has an estate plan or not. It doesn't matter if you have an estate plan or not. The thing you need to think about is the state already has a plan for you. In any state you live in, whether you're in Maryland, Delaware, Virginia, or somewhere else in the mid-Atlantic, the state has an estate plan for you. When you die without an estate plan, you're considered to die intestate, and your property is governed by state laws in that case. In most cases, what we assume when you die this way is you want your property to be divided up amongst your family members. We don't care what your relationship was with your family members. If you're married, contemplating divorce, and you pass away and don't have an estate plan, about 50% of your estate will go to your current spouse, regardless of what the relationship was between you. You may be no longer talking to your parents. If you pass away, a portion of your property may go to your parents. You may not be talking to your children. A portion of the property may go to your children. The other thing to think about this is we really don't divide property up in a way that may be able to keep a family business growing. We may end up having to put dollar amounts on every piece of property in the estate, figure out what equal would be based on the intestate laws, and divide that property up among the children. So if there's a viable farm in the picture, we may not have a viable farm after this. We may have to sell portions of the farm to give each child or each family member their portion of the estate because an estate plan wasn't developed. So with all that said, who can make a will? And I always like this quote from the Supreme Court of Arkansas. You don't really have to be a genius, a college graduate, or the smartest person in the world. You can make a will regardless of any of this. All you really need to be is of sound mind and over 18 years old to make a will. It's one estate planning tool everyone should consider. The issue with this is what happens as we age. Well, we may slowly start losing our mental capacity and not be of sound mind. One of the areas where we start looking at this, especially when you walk into the attorney's office, to start developing the estate plan is, do you have an idea who your children are? Do you have an idea who your family members are? Can you remember certain dates? Can you tell us who the president is? Can you tell us certain other things that we probably need to be aware of to show your sound mind? And if the person that brought you into the attorney's office is having to answer some of those questions for you, you may not be able to make a will anymore. You may not have that sound mind component that we're looking for. And you may be at a point where you can't make that will. So it's something we need to think about before we reach that point in our life and do it earlier so we can at least make sure it's clear and we're able to follow through on our intentions. Holographic wills, that's an example of a holographic will right there. For the most part, all wills have to be properly witnessed. Regardless of the state you're in, there's going to be witnessing requirements. You will not sign the document unless there are witnesses in the room. Why? You're no longer there when we take this thing to court, to enter it into court and to start the probate process that we'll talk about here in a minute. So when we start this process, you're no longer there to tell us this is actually your will. So we have to follow a very formal process to make it clear that this is your document. Holographic wills have to be written entirely in the testator or your handwriting, the person who wrote the will. You have to write it. You can't type it out. If your penmanship is as good as this one, you might want to make sure we can all read it. And it has to be signed and dated at the bottom. I'm going to point out for Maryland and other states, these are still legal. Maryland, they're not legal. They're only legal in one case. If you're in the armed forces and you're overseas at the time you do it, the idea is you're contemplating death, and you should be allowed to do a will while you're overseas contemplating your own death. They're void if you're in the military 1 year after discharge. Who can amend a will? Well, the will can be amended by anybody at any time. It just requires you to go back to the attorney's office and start the process either over again and draft a new will, or we'll draft a codicil or a document that amends the will with whatever changes you want to make. You cannot make margin notes in these things. If you get mad at your children tomorrow, that doesn't count. You have to go back to the attorney's office, work through the process again. Why? Again, you're not there at the time, so we only care what was officially witnessed and followed the proper process. We don't care what margin notes or who you crossed out in the will. If you want to change it at any point, you got to go to the estate planning attorney to do that. The thing I always highlight with this is, if you're going through the proper process where you're communicating and you're working with the goals and we're modifying this thing as we go along, there really should be no need for margin notes. You should be automatically, going to the attorney's office to have it modified at that point to make the plan work more smoothly based on changes you've seen. Now, with a will, this will take into account most of your property, but there are certain things that will pass outside the will. What are some of those things in question? One would be life insurance policies. You've already designated who the beneficiaries are when you die. So this is something we don't have to think about at this point. Payable on death accounts. You've already selected who that bank account goes to upon your death. And I should point out, doing each one of these is considered a form of estate planning. You are taking care of things before you die and making sure they go to the next person in line, depending on what they are. You may have payable on death accounts for business partnerships or things like that. You may have joint bank accounts with a spouse. Those will typically go to the surviving spouse or surviving business partner, depending on how they are. Real property held with rights, held as joint tenants with rights of survivorship. In most property, as long as it is not held as joint tenants with rights of survivorship, it can pass through your will. Property held with rights of survivorship basically says whoever the remaining joint tenants are or the remaining joint tenant, they're the next people that take over your share at that point. So if you have a property with 3 owners with rights of survivorship, one of you pass away, the 2 remaining owners become half interest owners in the property. When the next one passes away, the survivor gets the full piece of property. We don't have to worry about that in the will. Trusts are another tool we can use in this. Unlike a lot of estate planning tools, they're not for everybody. You need to talk to an attorney about this if you're actually going to consider doing one, and work with them to understand the pros and cons of these things, because they may not actually work for your situation. So who should consider doing these? Well, for those people hitting federal estate tax limits or even state estate tax limits, you should think about this. For 2019, the federal estate tax limit is $11.4 million for an individual. If we're a couple, you get $22.8 million, and it needs to be a married couple in order for that to qualify. If you have children who are disabled or a family member who's disabled that you are providing care for, you may want to have some sort of trust set up to take care of them, with the property in your estate being used to take care of that child or that family member. And then family members who may not be able to manage their own needs, they may be able to set these up ahead of time just to be able to manage their own affairs if for some reason down the road they're unable to take care of themselves. We see these a lot as testamentary trusts. These are trusts that are created in the will. Typically we see this for either a disabled family member or a minor child in some ways to provide for their benefit. A living trust, this is what a lot of people consider in their estate plan. It's created during the trustor's life, and it can continue after their death up until a certain point. It's used by many people as a way to avoid probate, and we're going to talk about what probate is with a will here in just a second. It's revocable. They come in 2 forms. They're revocable more or less up until the point you die. At the point you die, they become irrevocable, but revocable means you retain control of the trust to change the beneficiaries, trustee, and terms, and you can dissolve the trust. Irrevocable means they're permanent and there's no ability to change the trust. So why might you want to consider one? Well, it avoids probate costs in most states. If you own property in multiple states, and I need to be clear, it's mainly real property, any, land, houses, buildings attached to land that will classify as real property, that's going to potentially cause you to have to do probate in multiple states. If it's a personal property like a boat or something like that, that's not attached to land, that's going to transfer under the state laws that you passed away in. So if you pass away in Maryland and own personal property in Delaware, Virginia, somewhere else, that property will transfer under Maryland law. If you pass away in Delaware and own real property in Maryland, you're going to have to do probate in 2 states, potentially, if you don't set it up with a trust. It allows for management of assets if you become incapacitated. You can typically distribute assets much faster to the beneficiaries than the probate process. Typically, once we get the bills paid for the estate, we can then start passing around, dividing up the property according to the terms of the trust. Why might you not want to consider these? These might slightly be more expensive to do than a will. You're going to need an attorney. You're going to have to talk to the attorney. You're going to have to make sure everything's set up properly and that you understand how to administer that trust properly so you don't get in trouble down the road. Expenses can potentially outweigh benefits at some point. You may have to pay down the road for somebody to manage the trust if you don't trust children or you don't want children to be involved in managing the trust. So as we're looking at this, we really have 2 estate planning tools that most people use. We either use a will or a living trust. So what are the pros and cons of these things? With a will, you control the property up until your death. Most people are control enthusiasts and want that in their lives. You get to direct who gets the property. You have to select the executor and the guardian. So the executor is the person that goes through the probate process, makes sure the bills are paid on time, and then distributes the assets. If minor children or disabled children or disabled family members are involved, you can select guardians for those people and make it clear in the will. Once the property is distributed and the assets are distributed, you don't need the will anymore. You have to probate it. That is a timely process. It's a very public process. You take the will to court. It's proven to be your valid will. Then we start, letting people come in and potentially make claims against the will. Depending on the size of the estate and how effective the estate planning processes work, there may still be a contest to the will, especially if you cut family members out who were expecting to be included in the will. This is one reason why we always say communication is important, because if the family member is aware of why they're being cut out, they may be less likely to contest the will down the road. They're easily contested. Even if you put in a no contest clause, they can still be contested. It takes time and it's a very public process. The will is put in the public record. Everyone could potentially see how you're distributing your assets, but you have to think about this in your lifetime. How many times have you wanted to go down to the courthouse and look at a will? Something to think about. People are often scared about the publicness of wills, but at the same time, how likely are we to actually follow through on going to look them up? They're very state specific. If you have property in multiple states or you move, you may want to make sure that the will still is valid in states where you own multiple properties, or if you move from one state to another, just to ensure that your estate plan will still be valid. So the other tool we talked about is living trust. Well, one, it eliminates the need for probate. It's not public. It's difficult to contest. No need for guardians to hold assets for minors. Why? You already have a trust. I should go back. It's difficult to contest. Why? It's a private document. We're no longer filing a will in the courthouse. We have a private document between the parties that are in the trust. That's why there's no public information. It's a private document. You don't have to go through probate with this. There's potentially trustees' fees involved in this. If the trust is not managed potentially by family members who are willing to give up the fees, and you have to turn it over to a bank or another professional company, they can charge fees on this to manage it. It's potentially going to add asset management complexity to what you're already doing. That's why you should talk to the attorney before you do this. You still have to coordinate this with every other estate planning tool that we're going to talk about after this. You will still need a will. Oh, I went backwards. You will still need a will. Why? You may get property and forget to put it in the trust. So we just need a will that tells us what to do with all that property that's not in the trust. It's probably not going to be that much property, because once you get it and you're managing it properly, most of your property is going to go into the trust anyway. The other estate planning tools that even the will and the living trust need to be coordinated with are durable power of attorney. This just appoints an agent for you to handle business and financial dealings that may arise when you become incapacitated. So the power will last until the authority is revoked. So typically they'll state the causes where this authority would become available to the agent. And then once either that issue goes away, you go under for surgery. Somebody may have the power of attorney for you to make business decisions for you while you're under having the surgery. And that power will last either until you come back and you're, at that point out of anesthesia and awake again and able to make decisions, or if you pass away suddenly, that power goes away. You can't give power to someone past your own death with a durable power of attorney. The other thing to think about is we have a healthcare proxy as well. It's similar to a durable power of attorney, but it is specifically to make healthcare decisions for you. Agent only receives decision-making power when the primary doctor determines you can no longer make your medical decisions. I put this in here sometimes because these were problems, sometimes, but not normally. If the healthcare proxy's authority is not limited, then the agent could be entitled to make decisions involving whether or not to remove you from life-sustaining methods. That is typically no longer the case. Typically, they're pretty limited in authority, but sometimes they may be drafted poorly and be too broad. The other thing to point in here is, and these were problems early on, is they also need to make sure they're HIPAA compliant with federal law. If your healthcare proxy does not have the ability to actually look at your medical records to help make medical decisions, this could be a problem for doctors and whoever has a healthcare proxy. Most of these now do that, but it's something just to pay attention to. You might want to ask the attorney about it while you're in the office. The reason why they are no longer as broad as they used to be, the healthcare proxies, is most states have set up this idea of a living will in state law. It's also known as an advanced healthcare directive. It's basically, for those in the room that have done one, you already know that these are the most depressing documents you will ever look at because they will define every way you could need to be put on life-sustaining methods and whether or not you want it or not want it. And that's the whole idea. Is you're going to and you're trying to make decisions about your health care when you may not be able to do it, specifically when you want to be resuscitated, when you want to be left on life support, other issues as well. Why do you want to do this? Well, A, if you've ever been in that situation and had to make those decisions for a family member, it's probably one of the most stressful things you can do for that family member. You may not always know what they are, especially if you're the child and you've always made bad decisions in your life according to the parents. So are you making the right decision? Are you doing what they would want you to do? Well, no, they no longer have to worry about that. You've already specified what you wanted. That burden's not on them. It's already made for you. You made it yourself. As I pointed out earlier, most of us are control enthusiasts. This allows you to have some control in your life and sort of pick out the ways that you do or do not want some medical treatment. So some tax considerations in all this as well. Federal estate taxes. I've already hit on what it is for this year, but it is pegged to inflation. It goes up each year. It's $11.4 million this year. For a couple, a married couple, that doubles to $22.8 million. Sometime around November, IRS will release this amount. The one thing to point out about this current level is it will go away, if I remember correctly, in 2025. The tax law that was passed in early 2018, late 2017, I can't remember when, has sunset provisions in it, and it will revert to whatever the federal estate tax would have been in 2025 based on the old law. So it'll be probably close to about $6 million for an individual in 2025, maybe a little over. So it's something to think about if your estate plan is geared towards this. You will need to pay attention to some of these law changes because they may impact you down the road. The other thing that was created roughly 10 or so years ago in federal law is this idea of portability. Portability allows the surviving spouse to use any unused portion of your federal estate tax exemption with their estate tax exemption. For the most part, property passes to the surviving spouse tax-free. So any property that passes tax-free that doesn't count down against that federal estate tax exemption can be used by the surviving spouse. The thing to point out is, and most accountants have gotten better, there were issues at the start when this came out, making sure appropriate tax forms were filed timely. That typically is not an issue anymore. The other issue that pops up is you can't get remarried if you're banking on portability. Why? Because at that point, you're no longer the surviving spouse. You have a new spouse. So portability goes away at that point. So it's something to think about if that's a part of the estate plan as well. Maryland was pegged to go to the federal estate tax exemption by this year, but when the Congress changed it and doubled it, Maryland set it at $5 million last year. It is not indexed to inflation, but there still is the ability to get portability. So there is this idea in Maryland, estate tax exemptions, there's about $10 million if you're a married couple. There is another special exemption in Maryland for agricultural property. This was created about 2012, back when the estate tax exemption was around $1 million. The state ag exemption for in estate tax situations is up to $5 million just on the ag property, and you have to agree to keep it in ag for 10 years. So there is some ability to exempt out just $5 million in estate tax. And I'm still not clear if this counts separately from the $5 million. I think it would, from the $5 million for all property. So this may be a way to exempt some additional property as well. The main issue potentially with it, depending on what the goals of the other people involved in the estate plan are, it has to be kept in ag for a 10-year period. Gift tax. Another way people may think about doing this and passing property on, especially as we get the plan worked up, there may be abilities to provide gifts to individuals. So I say in 2018, I forgot to update the slide. I always forget to update this slide. 2019, it's the same. It's $15,000 to an individual. It's $30,000 to an individual from a couple. So any individual can give you up to $15,000. Any couple can give you up to $30,000. You have two gift tax exemptions at that point. If you go over $15,000 or whatever it is, whenever it goes up again, it's indexed to inflation, but it only goes up to the nearest $1,000. So it usually takes 2 or 3 to 4 years to get up to the next $1,000. Any portion that goes over that amount, that gift tax exemption, that just potentially counts against your federal estate tax exemption, i.e. it goes down. So you can either pay gift tax or you can just count it against your federal estate tax exemption. The thing I always point out here is with gifting, there are strategies involved. There are lots of issues with gifting. It changes basis potentially in property, so you may want to talk to your accountants before you do this, because they will help you make wise decisions on how to strategize on how to limit your tax liability. The other things to think about in an estate plan is, for the most part, if we think about it, if you're just a family, no ag business, just, parents, some kids, that type of, it may be a really easy estate plan to work out. But what happens when we throw a family business in there, either a farm, or any type of family business? We may have issues that pop up. What if one kid has stayed and worked in the business and the other kids have gone off and done something else? How do we sort of address the issues that are going to exist? Because A, we may not have enough in the estate to make everything equal. The business may be the largest set of assets owned in this estate plan. How do we handle this problem? So the biggest question that always comes up, especially in ag, is how do we handle the farm kid versus the city kid? In almost all cases, equal will never be equitable. And the idea is basically if we have, one working farm and we have 4 kids, and now we have to divide the farmland up between 4 kids, do we still have a farm? And if the farm kids work there from the moment they graduated high school till the day the farm has to pass to the next generation, how is that going to make the farm viable, and what has that done to the kid that's basically based his life on one business? You may have just forced that kid to have to figure out what to do in their life if they're 50, in their 40s, and they may not have any idea what to do at that point. So we often have to think about how do we set this up in a way that's equitable to all the parties, but not exactly equal. And one of the ways you can do this a lot with business entities, you can do it a lot with trusts as well. But business entities, since we haven't talked about them, we'll talk about them now. One way to do this is to use a business entity. You can set a business entity up where ownership of the farm resides in an entity that's owned by the heirs. So all the children could be a part of this. But we could have separate classes of ownership to where the on-farm successor makes all the decisions. They make, whatever decisions need to be made to keep the farm going. And the other on-farm heirs or off-farm heirs just have some participation in that business. The one reason we always point out communication is important in this process is if we think about it, if we never talk to the on-farm heir about, or the off-farm heir about any of this, what do they want? They may just want to be a part of the farm, and this may be one way to make them a part of the farm. They may want something else. They may want money. They may want just a piece of farmland that they're willing to lease back to the on-farm heir. But we need to think about this and figure out how to strategize to set it up in a way, especially if the goal is to keep the business going, in a way where the on-farm successor has the ability to keep the business going, which is why this is an important process to start. Maybe once the on-farm successor comes on the farm to figure out how we would start this process. We can use business entities as one way to do this. We could potentially use conservation easements as one way. If the farm hasn't sold any conservation easements and put property under easement, there may be a way to sort of equalize shares between farm and non-farm kids where the cash sale, and these are not donated easements I'm talking about, these are selling easements and trying to get cash for them, to where you may be able to give the cash to the off-farm heirs as a way to sort of equalize that share between the children. The other issue that comes up is sweat equity. And randomly, no GIF ever fits my PowerPoint well, but this GIF actually does. If anybody's seen Monty Python in the Search for the Holy Grail, there's this scene where the Lord comes in and looks at his son and looks out the window and goes, "Lad, all this will be yours one day." Well, in England, that's enforceable. If I'm on the farm working for my dad and my dad looks at me and goes, "All this will be yours one day," and doesn't put together an estate plan, that's not going to keep my brother and my sister from getting a piece of the farmland. At that point, because he didn't do anything, his word is not that valuable. And I've just put up a lot of work for nothing. I'm not going to get anything different than my brother or my sister are going to get. So it's probably going to create ill will between family members if that happens. So what the thing we always point out is we need to formalize these relationships early on. We need to make sure that people are getting paid in some way that's fair to what their contribution is to the farm. So they're not putting in equity into the farm that's being uncompensated through sweat. It may require the on-farm heir to work less on the farm and work more at an off-farm job in some cases. But we need to think about what that is to make sure this stuff is enforceable down the road. And hopefully that came through on the audience. But we need to think about what happens in these things if people get married or divorced. So what happens if an on-farm heir gets married? And I really wish there was a way to stop that music. What happens if the on-farm heir gets married during all of this implementation? What do you have to think about? We may have to think about what Kanye West taught us. Kanye West taught us, if you ain't no Trump, holler, we want prenup. You may have to think about a prenup during this process, because if we have an on-farm heir that gets married during the implementation, we may have a spouse that may now have a claim to the family business. And if there's a divorce, that may require the farm that's been in the family for generations to now be given to someone that's not part of the family anymore. So we need to think about how do we do this to make this clear in some cases. This is also not a really fun conversation to have with the potential incoming spouse. The other reason we need to think about prenuptial agreements is what if we have a complex family? We have a husband and we have a wife, and they both have children from previous marriages. We have farmer, first his spouse passes away, he, finds a widow woman that he falls in love with, they both have children, they're both not going to have any children anymore. Just kind of common in the area where I grew up in Oklahoma. So, what happens in these cases? You really do have to think about, in the Brady Bunch situation, which I kind of just described, only they didn't have a farm. What happens if Carol wants to make sure that family property on her side goes to the 3 girls? And what happens if Mike wants property to go to his 3 boys? They may not want family property that wasn't created once they got married to go to people that weren't a part of that family. A prenup's one way to do that, where we just come in and we say, we recognize that we're not going to have kids. Anything we bring into the marriage goes to our kids and isn't considered marital property. Anything that's created during the life of the wedding or during the life of the marriage is considered marital property, and it's got to be divided up equally among the children in some way. These are things we have to think about in those cases just to make sure that property goes to who we want it to. Because we always shouldn't assume that in the end the surviving spouse will do the right thing. This is one way to take the surviving spouses out of it and just make sure everything goes to the people we want it to. So what are some other things we need to think about in this? How many people create a perfect plan during this whole process? Or at any point in their life have created a perfect plan? Odds are very few of us have. If you're creating perfect plans all the time, I want to talk to you because you're doing better than I am. But what happens is throughout the planning process and the implementation of the plan, because once you get this plan and we figure out how we're going to pass the farm on to the next generation, we may have to start passing portions of control over to the next generation so they get management experience, so they get the ability to know how to manage the farm, to keep it going for the next generation. That's something today we haven't talked about. We talked about it in the larger set of workshops. But what happens if somebody has a birth during this? What if somebody dies during this? What if somebody gets married during the implementation of this process? What if there's a divorce, a disability, or anything else that could potentially happen? What if we buy a big asset? What if we get rid of a big asset? What if tax law changes and reverts to what it was? The tax law expires, what happens then? That's a major legal change. What happens in that case? Well, at the same time, we're looking at all these things that may cause us to do it. What if we just did it on a regular basis? And we did it as just something normally either every 6 months to a year we're checking in with the family members who are part of the plan to make sure everything's still working. We're holding regular family meetings to make sure that this process is still working properly. And that's where we really need to get people to get to this regular basis and not just thinking about, these major life events. I give some examples. What happens if there's a change in estate taxes? What do you do at that point? You got to go back and revise the plan, especially if it's lowered in a way that you could potentially take a tax hit. What happens if the on-farm successor passes away? What happens at that point? If we don't have a natural heir that's going to take over, we may not have the ability to keep the farm going as a farm at that point. We may be looking at leasing it out. And how is that process going to work? Is there somebody we can bring in to become the farm manager that then, manages the farm, and then the family members monitor and treat it like any other business? What happens if one day the on-farm successor wakes up and says, you know what, I can make more money doing X and no longer wants to farm? What do we do? These are all reasons why we'd have to sit down and think about how to manage this and change the succession plan and revise the estate plan. That's what I need to put in here at the end. Well, this whole process is going to require estate and transitioning planning is going to require some communication. If you didn't pick up on that, a lot of what you're going to have to do is talk to family members and figure out what's working, what's not working, what do they want to do with their lives, what are they looking at. And the family members have to be honest in this too. They have to really do, and this may require mediators to come in and really work with you to be able to get to the point to where everyone's at least being honest in the conversation. Tools discussed only helpful once we know what the goals are. Hidden in all this with communication is goal setting. We need to kind of know what the goals are, and then we can kind of start looking at the tools to figure out what tools will exactly work for us to achieve those goals. Oh yeah, how many people want to talk to their families about, death? That's what you're going to be doing a lot of. And that's what a lot of this process is going to entail. And at that point, I think I can hit escape. And if you guys have any questions for me, we can start taking them in the chat box, and I will leave up my contact info.
Yeah, so if anyone has any questions for Paul in reference to the presentation he presented today, just use the chat box. Again, you'll want to use the arrow and hit everyone before typing your question. Thank you, Paul. That was a lot of great information.
No problem. I'm trying to see if anybody had any questions.
Yeah, we'll give them a few minutes to type those.
So I see one, which is what is
the legal process for setting up a healthcare proxy?
Typically, you'll go to the attorney's office. They will draft up the document, which will typically require you to come in mind with people who are willing to serve as your healthcare proxy. And then you guys will have a conversation. Typically, you and the attorney will have a conversation reviewing what's been drafted to make sure you're comfortable with everything that they have drafted up for you. And then after that, you'll sign it, notarize it, anything else. Yeah, the medical field will. They need to be pretty much, you need to have a copy of it to make sure that the medical field will accept it. You can't just walk in and tell the doctor on blind faith that you have the healthcare proxy. You kind of need to have the document with you so they can have it on file. It's probably better that the person, whoever you hold the proxy for, has given it to the doctor, if they have a general doctor or any specialist, just so the doctors are aware that this is actually coming from the person. But for the most part, if you walk in, they should be accepted. And I'm hoping all the people with audio problems got it fixed. Are there any more questions?